Before then, I would like to welcome the chairman of this occasion, I also welcome one of our own, was the vice chairman of the Premier Bar, Third Honorable Justice O.J. Okeke. He was here in time.
Almighty God, our Creator, we pray you to be with us in all our deliberations and to direct our endeavors so that we shall continue in all humility to glorify thy name and do that which is right and just for our profession, its members, our fellow men, and our country. Amen.
Thank you. I go to page 3 of the program leaflet for our national anthem. I know, because I know most of you will start with our rise of corporate talk. Then we now have back to the days when people like Chubaiwas and Dabogi were in primary school. So, do we take the national anthem? Please, we have to rise and take the national anthem. Thank you very much. You can be all seated. While we are going through the national anthem, centenary, FMO Piano was music director for many years of Diocese of the Niger. He started from Enugu. And many of you would not know that the pipe organ used at his home church in Idale was bought by him when he was coming back from London after his studies. That organ still to date still there. So it will be out of place that we should be doing this kind of a thing without singing one or two hymns. And these are his favorites. So, gentlemen, I pray you to listen attentively. Thank you very much. Yeah. Chartered Institute of Arbitrators is here. You're welcome, sir. Is there anything? So, no conspiracy is going on. Huh? Who is it? Oh, that was. Are you also there? There must be a conspiracy going on. That with the CJ here, Honorable Chief Judge of Anambra State, and you'll be curtailed. Just one sentence, and I'll assure you, all of you will be at your proper place. And I have this protection here, so fine, the more Esquire. Very, very senior lawyer. You're welcome, sir. I'll also acknowledge another senior lawyer, S.N.S.S. who is one of our lead discutants today. You're welcome, sir. Please, we'll go on, we'll take more recognition at the appropriate time. What, are you ready? Please give us another. Is he here? Please, before you cancel our listing. Please go on. Now sitting in Onitsha. I look forward when you go back to Twitter. Only the presence of past secretary, past financial secretary, past chairman of the Premier Bar, Honorable Justice Dennis Umarechis. You're welcome, sir. I would like to acknowledge them. Some of them, not all of them. I acknowledge Chief Benson Oduku, Ajay Dike Afurukwe, one of our Ojuku, Masijuku. You are welcome, sir. acknowledge the presence of Denton, Chief Denton Ojukwu. You're welcome, sir. Sir Ernest Dibekwe, you're welcome, sir. Chief Chibuzo Onunkwo, our own Chike, Mr. Chike Dodge, is also a member related to Obiawona. Chike, you are welcome. Chike, are you now in Abuja? Chike, I'm asking you specifically. I see you most of the time in Abuja. I don't know. You have left Abuja. Please. Okay, down. This is Ada Okonkwo, Engineer Okechukwu Obiano, Udechukwu Obiano, Azubike Obiano, this is Joy Okeke, and Barrister I.K. Obiano. You're all welcome. You can now see with the eminent lawyers, judges that are here today, you can now see for yourself that your late son was highly regarded. He's also highly regarded. It's not easy to get an assemblage of lawyers. Today is a work day for lawyers. All of us are here. Some of the judges, magistrates, rose early today in order to honor FMOB. A man of great part and very senior lawyer for that man. I would like to go into so much details about him at the appropriate time. The proper person will do that. Thank you very much. We will recognize some of the magistrates and deputy chief registrars who have come to be with us. I'll start recognizing our worship, Genevieve Sakwe. She is presently the chairman of INSEC of FIDA Anambra State. Madam, you are welcome. You have promised to give us a free and fair election. We lawyers are battle ready. If you don't get what we expect, we will go to the court. This is not a matter of go to the court. We will go to the court. I said the court, not go to the court. Thank you, madam. Another DCR, Stella Okechukwu. DCR in charge of Onitsha. You're welcome, madam. For worship, Obi Erinne. You're welcome. No wonder. Ozuna is very, very quiet. I will recognize the presence of the worship Aaron Zebu. You're welcome. Your worship, Chinyerebe, we are welcome. Then, Kole Ashara, immediate past chairman, MBA, DMD. You're welcome. Presentation of paper, if it is permitted by the chairman of this occasion. Lord, will we go ahead? Respectfully invite the chairman of the occasion, Honorable Justice Oyama Anthony, Chief Judge of Anambra State, will give us his opening remarks.
I will especially recognize this servant, Ezo Meni. They're retired. They serving my laws are always with me. My Lord Ezo Meni, you're welcome. My worry is that these decorations here appear to some of us who are not too tall. I don't know whether I'm being seen. I have to stretch my neck to the seat. But let's manage this well. Learned Excellence, I recognize out of protocol establishment, EEC Okereke, a life bencher, one of our elders from Enugu. I want to acknowledge you specially. Your honors, your worships, the presidents of customary courts, all former commissioners here, the ancient chair, G. Osapwe, learned gentlemen, as led by the leaders, NBA chairman on the branch, whom I acknowledge as the landlord. The chairman of the chairmen, I think I saw him here, the Okaba chairman, saw him briefly. Any clergy here, all the title chiefs. I saw our learned friend Enwezo fully dressed. You're welcome, sir. The choir, I have to acknowledge you. We have been listening to your tunes and we hope to listen to more. Ladies and gentlemen, thank you so much.
Thank you.
I think any of us who is here, we know why we are gathered here. The master of ceremony, in his characteristics, took over this ceremony. I forgot there was a chairman. Well, I didn't mind because he made my work easy. I don't even mind sitting down so that he would not fall. So, MC, I'm very grateful. Well, we'll continue to thank God for a beautiful day He has given us. Despite all the perilous times, I can see most of us are smiling. I can see E.D. Chukuma, very bright, smiling, and I hope that the trick behind it will get to some of us. Well, I asked myself a question. I said, why are we gathered here? And I tried to find an answer. The answer I quickly found was that we've come to celebrate a man whom we all loved and cherished. But when we say that, I know that 50% of the people here do not even know Chief Obiayo or never saw him physically. Most of us here who are below 50 may not have had real interaction with Chief Obiayo. But for those of us who were privileged, and when I mean privileged, I mean privileged, to have interacted with him, I think we share very good memories of a man who was really a legal, what we call legal juggernaut. A man whom we count as being courageous. A man who will look at, and he will look at you at your face and tell you the truth. A man who loved God and found time in music to praise God. A man who was ready to serve his people and serve mankind. No wonder down there in Idan they call him Okulora. He was one of the people who made sure that Idan got their independence. I'm sure many of us don't know that Idan got independence from Alon. Many did not know that. And so I think you are here. You are hearing that. I doubt whether you know. Okay. Thank you for giving them independence. This man we are celebrating today died at the age of 100. He left a good name. He left good deeds. And I think that is all we are celebrating. The man has died. He has been happily buried. For us who will assess him, I assess him as being in heaven, as far as I'm concerned. But God knows the best. But we are celebrating him, we are celebrating his name, we are celebrating his good deeds. If you did not meet him and you had no time to interact with him, maybe you would have interacted with one of his children. Your interaction with one of his children will give you an insight of what the parents looked like. Well, I'm especially privileged because I met the man, I met the wife, and I'm also interacting with the children. By the grace of God, my late father was a schoolmate, let me not call him classmate, a schoolmate at what we call the prestigious DMDS. I'm sure many of you know that school. Well, I didn't attend the school. I didn't have that privilege. I think I attended somewhere better. I'm sorry, you can't crucify me. I'm talking as the chairman. Now, the celebration of today will be in 3 phases. The first phase is the proper law colloquium, by which means we are trying to keep in memory a man whom we know that really practiced law in all, so that it's not just used for us. To be a legal advisor of an university at that level. So we are going to have a law colloquium which I will beg the MC. We will start immediately thereafter. All other distractions can wait. I also see that the topic here, so there are certain things you don't talk about the job in the body. Once you do that, some of us will find ourselves being embarrassed. Because, well, it's always easy to discuss judges. But while discussing judges, let us remember that judges come from the bar. They are all lawyers. You can't be a judge without being a lawyer. So if you are a bad judge, it means you were a bad lawyer. So that is my own interpretation about that. The second phase will be tributes. Well, opportunities will be given to most of us to say 1 or 2 things. Those who don't know about Chief Festus, Chief Barrister Sir Festus Mbadefo Obianyo Esquire Okulora. If you don't know much about him, you can just guess. Just presume that he was a good man and that he was a successful lawyer. You can talk on that. Then the third phase will be entertainment. MC, that is my opening remarks. Can you come and take over so that we start the debate? Thank you very much.
Thank you very much, CJ. As directed by the chairman, immediately the presentation of paper titled "Let's Jettison the 1999 Constitution: A Critics View of the Appointment of Judges," Sir Ejike Ezema, Senior Legal.
the Chief Judge of Anambra State and Chairman of this very august occasion, His Lordship, Honorable Justice O.M. Anyache, FCAR. My Lords, the Honorable Judges of Anambra State herein present, my noble Lord, Honorable Justice O.J. Okeke, retired Justice of Federal High Court, retired Judge of Federal High Court, Your Worships, Presidents of customary courts, learned friends, distinguished guests, permit me, gentlemen, if I, by any means, oversighted recognizing you appropriately. Well, I had a signal. Let me start by saying from the outset that I do not intend to go troubleshooting. This warning becomes imperative in view of certain views expressed in some clients concerning certain topical issues I have treated and some of which cause some stir in international discourse. I have also come to realize this thought to avoid completely some stirs in genuine discussion and the X-ray, the genuine discussion and the X-ray. I have also enjoyed, however, discussions that revolve around the Constitution and constitutional developments. And I found this treatise certain connection with some of the papers earlier presented in certain fora, particularly at the Nigerian International Conference Center, where I spoke on rule of law as an instrument for national development. And then the paper presented at Golden Lily Hall, International Trade Fair Center, Accra, Ghana, where I dealt with the paper Constitutionalism as an instrument for development of nations. As the second speaker privileged to speak after Honorable Justice Julius Abega, former acting Chief Justice of the Supreme Court of Ghana, I called for a review of the composition of the International Criminal Court of Justice. Well, most controversial might be when I spoke on democracy as an instrument for development of nations at DIRA, Dubai, United Arab Emirates. Well, some states were caused by these persons. I am therefore reluctant to cause further step. But I must, however, still say that it is difficult to make a frank discussion without sometimes pulling some punches. I would prefer to avoid that. There are some calls to the paper today. There has been several calls from many reporters for a new constitution for Federal Republic of Nigeria, which many reasons has been abused. I have declined to lend weight to this call. This need to jettison the 1999 constitution, in my view, will arise if there is fundamental defects in the said 1999 constitution, or a fundamental need that may alter the political structure of a society, in this wise Nigeria. It is my view that a look at the constitutional development of Nigeria does not lend weight to the call for the jettison of the 1999 constitution. The 1999 constitution of Federal Republic of Nigeria appears to be the most easily tinkered piece of legislation in Nigeria, starting from the amalgamation constitution of 1949 to 1999 constitution. Nigerians appear not to have given the least respect to our constitution. In my paper at the Golden Lily Hall International Trade Fair Center, Accra, I have contended that constitutionalism and its development affects and is influenced by nations' development. This could also be seen in the constitutional development of Nigeria from 1914 to 1999. I do some analysis. Now, by 1981, Lagos was a colony. And and it did not become a separate colony with its own district governor until 1986. Between 81 and 74, the colony of Lagos was under the jurisdiction of Governor of West African Settlement, whose residence was in Sierra Leone. Between 1874 and 1886, it was under the colony of the Governor of Gold Coast. A very important organ of government which was established after the annexation was the Lagos Council, vested with exclusive jurisdiction over colony of Lagos. The council, which comprised of 6 officials and 4 unofficial members, was dissolved in 1992. During 1922, please. During this period, no African, no Nigerian were appointed into judicial office in Nigeria. This gap was not addressed despite the 1914 Lugard Constitution and the amalgamation of Lagos Colony and Protectorate of Nigeria. It was until 1920 when the National Congress of British West Africa, an association that pledged itself to uniting the 4 British West African colonies of Gambia, Sierra Leone, Gold Coast, that's Ghana, and Nigeria, wrote a petition to the Secretary of State for colonies and made a 4-point agenda, among which was the for appointment of Africans as judicial officers. The demand earlier for appointment of judicial officers, Africans as judicial officers, was turned down by the Secretary of State, Lord Miller. Of particular mention is the harsh criticisms from governors of Gold Coast, that is Ghana, and Nigeria. Sir Clifford was in particular very sarcastic in his criticism. The delegation to London was not in vain. The Clifford Constitution of 1922, though came into effect in 1923, which followed the delegation to London, made provision for elected president. However, one of his greatest defects was the exclusion of members from northern Nigeria, an omission that might have been deliberate and part of the British fable divide and rule device. With the coming into effect of Richard's Constitution in 1947, though called 1946 Constitution, certain developments took place with this Constitution. In 1946 Constitution, you now found provision for regional government. The purposes of Richard's Constitution, as stated in the Nigerian Sessional Paper of number 4, 1945, was to promote unity, provide adequately for the diverse elements within the country that made up the constitution of the country, and to secure greater participation of Africans in their own affairs. It also resolved the exclusion of the northern province of Nigeria. By the time we came to Mafasin Constitution of 1950, well, let me make a little comment. When we came to 1946 Constitution, though we have regional governments, but we discovered that those regions were still without power, without authority. In fact, one author described them as assemblies of dignity. So the legislative is a constitutional matter. That in case where there is conflict, you know what we have in the present constitution. Where there is conflict, the federal law prevails. But in that 1951 constitution, because regionalism was still respected, the provision was for the regional laws to prevail over the central law, where the was vested at the federal level, at the central level. Let me use the language. Now, when we get down to the independent constitution, we found that that constitution came into effect basically because Nigeria was on the verge of independence. And when we became Republican, there was this 1963 constitution because of our Republican status. Now, that was the beginning of the core, the beginning of the argument that constitution, whether constitution was homegrown, whether constitution came from the people. Well, for the first time, Nigerians said that there was a constitution made by the people and for the people, that it was homegrown. That was the 1963 constitution. Apart from this constitution, no constitution, even the 1979 constitution that took place because there was going to be a handover to civilian regime, and the 1999 constitution that came into place too, because there were a civilian regime. Only the 1963 constitution has ever been seen as a constitution that came from the people. The argument has always been that it did not emanate from the people. But I ask myself, is it possible indeed for the whole members of the country, the whole citizens to sit down together in one place and start legislating over the laws, over the constitution of the country? Is it not the same representatives of the people that we move, sit down together, talk about this, and then make their inputs, which are eventually verified and authenticated by one quarter or the other? And that is the case of the 1999 constitution, for which my view has a lot of call has already also been made for the constitution to be jettisoned. The fact that the contributions of these people are nothing. Are we saying that they haven't done much to bring whatever developments, whatever inputs we needed to make into the norms, the ground norms of the country? My position is that it is wrong, and I do not subscribe to the call for a jettison of the constitution, because for constitution to be jettisoned, there must be a fundamental defect. There must be a fundamental defect or the fundamental departure, which you can see from 1922 constitution to 1999. 22 elected principle, because before then there was nothing like that. The new constitution was needed to give birth to such. 46, because we were going regionally, and the new constitution was needed in that wise. And in 1951, a move back to what seems to be presidential system, but still with the arm of regionalism, was in place. 1954, then it became clear where we were going. So when we look at this, even 1960, the independence, 1963, the Republican, you find that there must be fundamental departure that will give birth to a new constitution. The new constitution, in my humble view, isn't enough, simply because they said the person who was heading the country at that point in time was a military or was a head of not. My view, therefore, is that we have not gotten the right scenario upon which a call could be made for a new constitution. Of course, I am not saying we have a perfect document as our constitution. So I subscribe to amendment. I subscribe to an amendment. The judges of the Supreme Court and High Courts were to be appointed on the advice of the Judicial Service Commission, which consisted of judges. Those judges would only be dismissed on ground of inability to discharge the function of the office, or for misbehavior on recommendation of Tribunal of Judges, confirmed by Judicial Committee of the Privy Council. It's been argued in some quarters that appointment to the bench is now family business and politicians have captured the judiciary. Many contentions have been made that lends to cast a negative impression over appointments made. However, while there are possibilities and cases where appointment may seem questionable, the fashion or vogue of discrediting appointments, mainly because one has a relationship with the person or the other, if the person appointed meets the requirement or standards set for the qualification of the particular position, may not be a solid card. The question should be whether or not the standard set is met or not. There is also and not because we throw overboard every other ground. So point just at one fact, that because he has a relation with whether he meets the standard, he doesn't meet the standard, becomes immaterial. So my call, particularly for us, sometimes I see we are coming through, because my call generally is for us to consider all the grounds together and see whether the basis for our contention stands or whether or not we will vary the position we have taken. It's then the lawyers also join force in commenting over appointments and even judgments we are yet to read. Conspect them, I advise. However, the appointing authorities should examine more critically candidates to be appointed and ensure that meritocracy and right qualifications and standard are maintained and sustained. To do otherwise will be to leave the fourth gate of persons raising hue and crying about the appointments. The eventual derogation of confidence in the judiciary will be a consequence. Now, if we take a look at our current constitution, you will obviously find the need for amendment of section 231, 237, 250 of the 1999 Constitution. These deals with the appointment of judges. These sections deal with the appointment of judges. The peculiar thing in these sections is that you discover that the head of the executive makes the appointment of the Chief Justice of Nigeria, Justice of the Supreme Court, and even federal judges. The same will on the recommendation of Judicial Service Commissioner. The same in the state, the governor makes appointment of the chief judge and the judges. Then to worsen the scenario, you will see that these justices and the judges go to the National Assembly for them to be confirmed. The judges of the state go to the State Assembly for confirmation. I am saying with respect that this is a derogation. And the need to, urgent need for a call for a departure from this position and a call for amendment of our constitution to, in order to take care of this so my call is that yes to an amendment, but no to jettison. And that one of the areas that need to be considered in this era where we raise issues over appointments of judges or justices, we need to take a close look at these sections of the Constitution and to invite what is concerned to do a drastic amendment to these sections. Yes, it might be correct to say that in some times the presidency makes the appointment, but then we must realize that our scenario and environment are not the same, and we have to do things that rhymes with our own environment and those that will give us the opportunity to bring out the best in those being appointed. This may not be possible where the executive does the appointment and the legislature will confirm. Funny enough, it is only the third arm of judgment that is tied down to these bridges. If you look at the executives, if the president is elected and there is no contest, he never goes what concerns him with the court. If the governor is elected and there's no contest, what concerns him with the court? If the legislator is elected and it is not contested, what concerns him with the court? But the judiciary is the only arm that will be appointed by another arm and then confirmed by another arm. And I say it is an aberration that needs to be attended to in our constitution. I think an effort was made in the 1963 Constitution to give some the necessary freedom and liberty to an appointment of judges. Now, under that constitution, the appointment we are on the advice of Judicial Service Commission, which consisted of judges. Those judges would only be dismissed on ground of inability to discharge the function of their office or behavior on the recommendation of Tribunal of Judges, on the recommendation of Tribunal of Judges, and confirmed by Judicial Committee of the Privy Council. In other words, you find that the bodies that take charge in this scenario were actually people that have to do with the administration of justice and not, well, political office holders. Well, gentlemen, I end on this note. My suggestion is not binding. My suggestion could be enlarged. My suggestion could be developed. But this is the common suggestion coming from me, that the appointment of the judges could be done by the combined force or body of benchers, body of senior advocates, Judicial Service Commission. The composition of this appointing body will be completely insulated from constitution, insulated from executive and legislative arms of God. On this note, I say that yes, I realize that this may not be possible without tinkering with the Constitution. That's why I make a call for the amendment in order for us to have the independent judiciary that we all look for. I say no more, and I thank you.
Thank you, Sir H.K. Ezenwa, Senior Chief of Nigeria. It's not easy to present this kind of paper. You need courage, you need knowledge. Well, I was directed by the chairman of the occasion, the Honorable George Anambra State. The discussant this paper will have our ground rules to say that.
My Lord, the Chairman of the occasion, the Honorable the Chief Judge of Anambra State, my Lords serving and retired judges, learned senior advocates of Nigeria, here present, and the life bencher and leader of the bar, Inukuba, my stand on the existing and established order of protocol by the chairman of the occasion. I understand that I have a limited time. My Lord, let me acknowledge that we noted the order my Lord made, advising us to be careful about what we say, and I can also confirm that the next speaker obeyed the order. I pray to do so. My Lord, because a colloquium is an academic meeting where experts are invited to deliver addresses and take questions, I take it that the question at this afternoon's academic meeting is whether the constitution, the current constitution that we operate, will be jettisoned. However, I think we should narrow it down to the appointment of judges or appointment of judicial officers, because I don't think based on what he said, because that's the paper actually to discuss. I agree with him that we will not jettison the 1999 Constitution. I also agree with him that some elements of executive interference or involvement in the appointments, I said that we should not condemn appointments based on relationship between the appointed officers. Let me first start with what many of us lawyers know. There is this case we learned while we were in the university under the Nigerian legal system. It's R against Sussex Justices, ex parte McCarthy. I think it's quoted in 1924 1 KB, page 256. Yes, Lord Chief Justice Lewis said this, and since then it has remained the well-known English authority on rule against bias. It is not merely of some importance. It is of fundamental importance that justice should not only be seen to be done, but manifestly and undoubtedly be seen to have been done. That is the problem with the issue of relationship. I understand that it is in obedience to the order of the CJ that the speaker did not go further. Let me use paragraph 20, third schedule of the Constitution, and paragraph 13, third schedule of the Constitution to demonstrate this. Paragraph 13 deals with Federal Judicial Service Commission. It's a 9-member commission headed by the CJN, with such other members as President of the Court of Appeal, CJ of the Federal High Court, President of the National Industrial Court, 2 non-lawyers and 2 lawyers. Of course, Attorney General of the Federation. Please remember that this FJSC is headed by the CJN. Its nominations or recommendations or selections are sent to the NJC for confirmation. Now, what is the composition of this NJC? You find it in paragraph 20 of the 3rd schedule. This is the composition. It has a 24-member composition. The first person, who is the chairman, is the CJN. The second person is the next most senior JSC. Third, President of the Court of Appeal. Fourth, there are 11 categories of members. The fourth, 5 retired justices of the Supreme Court selected by the CJN. The next, CJ of the Federal High Court, President of the National Industrial Court. 5 CJs, that is Chief Judges of States in Nigeria, including the FCT, to be appointed by the CJN to serve on 2 years rotation basis. A President of Customary Court of Appeal to be appointed by the CJN. A Grand Kadi of Sharia Court of Appeal to be appointed by the CJN. 5 members of the bar to be appointed by the CJN on the recommendation of MBNEC. But these 5 members can only sit in consideration of appointment of judicial officers. 2 non-lawyers appointed by the CJN, who are, in his opinion, people of unquestionable integrity. Now, what you have is this. Out of these 24 members, except President of the Court of Appeal, CJ of the Federal High Court, the next most senior Justice of the Supreme Court, President of the Court of Appeal, and President of National Industrial Court. The remaining 19 were appointed by the CJN, plus the CJN himself, who is the chairman. So we now have 20 persons who are either the CJN or appointees of CJN, constituting this NJC of 24 members. The CJN presides over the FJSC that sends a recommendation to the same NJC presided by the CJN, with 19 out of 24 members being appointed by the CJN. So what are we saying? When people like Professor Dekalo was the lone voice in the wilderness, many people were complaining. Many liked him. But look at what we are saying. If you remember those edifying words of Lord Chief Justice Heward, that we are not talking about whether they are related or not. But this thing, this transparency, let it even be seen as having been done. But the problem is this, and that takes me to the second point. I am not saying that the entire problem is with members of the executive interfering or getting involved in the appointment process, but I will give you an example of where it happened. But what I'm saying is that whether it's the CJN or the last person, all of us are Nigerians. And when the water is impure right from the fountain, even to get a cup of drinking water from there may be difficult. It borders on integrity because we have seen fathers preside over local arbitrations involving their children where they condemn the actions of their children. So, we must be careful in the people, when we are appointing people to these sensitive positions. I strongly believe that once we have a person of integrity, it does not matter whether he's the CJN or whether he presides over all these things. He can still maintain integrity, but please, let us remove that semblance of impartiality, that semblance of partiality. That is the problem. Now, on this issue of involvement of the executive, there is this case, Ajilaye against Fakayo. It's reported in 1998 for NWL, part 545 at page 184. What happened? When Chimbole Igena of the blessed memory was the governor of Oyo State, the then DPP Ajilaye signed an opinion which recommended Nasiru Bello to be executed while his appeal was pending. And in the opinion, the Fakayo, who was the chief judge of the then Oyo State, sitting at the Judicial Advisory Committee, which was the name it was answering them before it became the Judicial Service Commission, said that this man was not fit to be a judge. His reason for saying so was that the DPP admitted that he did not know that a person who has been sentenced to death or who has been convicted should exhaust his right of appeal. And he signed an opinion. Then the CJ said in his defense that he opposed that appointment, but that the then governor overruled him. That was the point that HKSN was making about interference of the executive in the appointment process. But my view, which is a slight departure from what he said, is this. I don't think it is necessary or necessarily the problem of executive interference. Even in the UK, the Prime Minister recommends to the Queen, now the King, and under the Constitutional Reform Acts of 2005, the UK Constitutional Reform Acts of 2005, what they have done is this. They recognize that the executive has a role to play, but there are institutions, there are organizations, like they have what is called the Judicial Appointment Ombudsman, that takes care of independently investigating complaints or objections to certain persons. And that is where involvement of the local bar, from where an appointee is taken, is necessary so that they comment on this person who is to be appointed. If you go to Kenya, for instance, there are two things one could pick from the innovations in the Kenya Constitution. The Constitution of Kenya 2010. For instance, where they do not want to involve the executive, Section 184(2) of the Kenya Constitution of 2010 allows, there is something they say in Igbo land, they say, Etuonyedi Omoneyama. They allow, that is, whatever your character is, your kinsmen know better. The judges, here we call them justices, there they call judges. The judges of the Court of Appeal are allowed to elect one of them to be president to serve for a non-renewable term of 5 years. But where the executive will be involved, the legislature will also be involved. What they do is this: they conduct public hearings where people will come and air their views, and they take it seriously. So, in proposing an answer or attempting an answer to the legal question that has been called up for determination in this academic meeting as to whether, with respect to appointment of judges or judicial officers in Nigeria, the 1999 Constitution will be jettisoned, my answer is simply this: it will not be jettisoned, because even those courts they demand, right from Section 6, subsections 1 and 2, that guarantees their establishment, and from Section 230 to 298 that this will Cap 7, the Judicature, those sections there have set up this platform. What we need is simply this alteration, at least to take care of some of these imperfections, some of these improprieties we have noted. Just take as a typical example what I've just said about paragraph 13 of the third schedule for FJSC and paragraph 20 of the third schedule for NJC. Now, as the chairman said, since the man in whose honor we are organizing this academic meeting left both a good name and good deeds, it is quite apposite that this constituency of his, while he was on this side of the divide, should take all steps to get it right. And one of the steps to be taken to get it right is to ensure that the appointment of judicial officers passed the basic international best standards practices. Thank you so much for listening.
Doctor, I invite SNF
and the Honorable Chief Judge of Anambra State, my lords, honorable judges, serving and retired, worshipful magistrates, eminent senior advocates of Nigeria, permit me to stand on already established protocol. My lord, in the paper so eloquently presented by the lead discussant, which I have the privilege of dissecting in this short discourse, he makes certain theses. The first is that it does not support wholesale jettisoning of the 1999 Constitution because there is no fundamental defect with that Constitution and because of the weight of the personalities who crafted the Constitution. The eminent Silk will rather subscribe to an amendment or alterations of the Constitution, especially as it affects appointment of judges, which is the cardinal focus of his paper. A critical look at the 1999 Constitution and the question we should ask ourselves in deciding whether to support or oppose the wholesale jettisoning of the same is whether the document, the 1999 Constitution, is serving the needs, the perceived needs of the people of Nigeria for whom it was made. An expert said that a constitution is only as good to the extent to which it serves the need of the people. From 1999 to date, it is clear that if we x-ray the application of the Constitution, its implementation, it has not been a rosy tale for the people of Nigeria. If that is so, would we continue with the amendments or alterations of the said Constitution has been going on, or would it be better to jettison it? The lead speaker said it does not. And I think it was in deference to the admonitions of my Lord the Chief Judge that the paper was circumspect and not wanting to rock the boat.
Say what you want to say.
Thank you, my Lord. Thank you, my Lord. And because I verily believe that if we refrain from rocking the boat in this exercise, our Father, in whose memory we are gathered, may not be very pleased with us. The truth is that the 1999 Constitution, for the ordinary man in the street, has failed to meet the needs of the people. It has failed to make government accountable to the people. Rather, it has elevated all tiers of government to a position of being masters and lords over the people. This time within my giving to me may not be enough to do justice to this conclusion, but suffice it to say that periodic tinkering with the Constitution by way of occasional amendments will not really address the situation. When a contract is bad, and it seems to be bad by the people for whom it was meant, it is equally true. It is better for the people to revoke the contract and draw up a new one. In the paper too, the eminent Sikh said he does not subscribe to the questioning of appointments of judicial officers simply because of their affinity to serving or retired officers of court associated with making the appointments. Again, the lead speaker was very moderate. If we take a look back just last year and this year to what happened in the judiciary circles in the area of appointment, every one of us, and especially the ordinary man in the street, has had reason to complain that it is not only unfair, it is immoral for a head of court who sits over the NJSC, the Federal Judicial Service Commission, and the NJSC, the final recommending body that recommends to sit on both bodies, and then recommend his progeny, recommend his kids to the bench of the Federal High Court, the National Industrial Court, and at the same time make an appointment of an auditor to review the activities of NJC from the same family tree. Agree that those people are qualified. Agree that they are as qualified as any other who we appointed. That the very concept of fairness and impartiality dictates that such a one, the head of court should not sit when consideration of the eligibility or otherwise of his child is being considered for elevation to the bench. The eminent Silk, who was the first discussant, has succinctly outlined the crying shame in the composition of such critical institutional bodies like the NJSC and the NJC. The NJC, out of 24 voting members, 19 of them are direct appointees of the Chief Justice of the Federation. In such a case, where is the guarantee that the appointees coming from such body will be anything other than the proteges of the head of court who has appointed everybody else? It is one of the greatest indictments of the 1999 1999 Constitution that such provision has lasted for the last 25 years, unchallenged, and still being applied by everybody. It cries for an urgent surgical operation. When we jettisoned the 1999 Constitution, it will go with it. No wonder there has been a cry for reversion to the regional Constitution of 1963. That things were not so bad, not so heavily and densely concentrated in one person. My Lord, gentlemen, if there is one thing we should go out with this, out of this colloquium, let it be that the bar and the bench are united in calling for an urgent reform of the appointing system. It is this kind of chronism in appointment that has been reflected in the last 1 or 2 years by critical decisions of the appellate and apex court in Nigeria, especially in the electoral cases, in which the common man is the one who is best placed to judge the judiciary, not lawyers, because many of us are interested parties. The common man in the street, if you ask them, they are holding the bench and the bar responsible for what everybody sees as an assassination of justice in the determination of the critical electoral petitions that took place last year. In such a scenario, would periodic tinkering of the Constitution need it? I venture to say we need a surgical operation that will uproot the cancer from the root. And then, still in his address and presentation, the eminence made a case for the appointment of senior lawyers to the bench, to the apex and appellate bench, straight from the bar. He did not develop on that point other than making the bare recommendation. But if we look back on some of the people who followed that route, like Chief Justice of Nigeria, Taslim Olawale Elias, and Justice of the Supreme Court, Augustine Nnamani, their input and output and contribution to the bench when they sat, when they graced the Supreme Court, gives credence to that recommendation. It has become the norm that the only route to the apex court is through a stint at the Court of Appeal, and to the Court of Appeal is a stint at the High Court. This has been developed and accepted as the norm. And when efforts were made to appoint some senior advocates to the appellate courts, including some of us here who were recommended, that recommendation never saw the light of the day. Because a school of thought feel that it will be depriving judges who have passed through the school from high court upwards of their opportunities to serve at the bench. I venture to submit with respect that it is time we revisit, get the best from the academia, get the best from private practice, and let them come to the bench and replicate what Justice Olawale Taslim, Olawale Elias CJN, and Justice Augustine Nnamani did at the Supreme Court. The there is need for that synergy, for them to bring in. And when you look at the performance of judges who went to the High Court from the academy, you have a lot to recommend them for. We remember our own Justice Oke Achike, who went to the court, High Court from the bench, who went to the bench from the Faculty of Law. Nikki Tobi, who went to the bench from the Faculty of Law, University of Maiduguri. We need to replicate best people and bring out the best. And we need to reject cronyism in all its form, parabolism in appointment of judges. No matter how well the person is qualified, the very fact that you are the nominee or appointee of your father or your mother who was the head of court puts upon you a heavy burden. And no matter how credible or meritorious your performance on the bench is, it will be difficult for you to live down that odium. So in conclusion, my Lord, it is my humble recommendation that this exercise, if it does not achieve anything, let it go out that all we are saying is that the people of Nigeria deserve a better constitution. The institution of appointment of judges deserve a more refined and result guarantee system than what is currently in the constitution. We need to do this and do it quickly to get our justice system on the right footing. I rest my case.
Thank you very much, as a distinguished gentleman. This is a topical issue.
I'm the chairman. Please let me, on your behalf, thank our resource person, Sir Ejike Ezenwa, SAN, and the discussants. They have spoken well. I must acknowledge them. They have been bold to say what they want to say. Why it became necessary for me to stand without joining issues. Majority of us have our views about these issues. We won't want to join issues. The only point I need to make, which we must take home, is that the last speaker was saying we. That whatever he says here is his personal opinion. It's not our general, it's not a communique we are passing. Otherwise, all of us will give our own views before we have a resolution. So when he urges us to say we have some amendments to do or to make to some of the things he said. But we will not have time for that. I will enjoy the host. If you can organize this kind of thing, maybe every year, we'll be sharing ideas and we'll have more time. Today we are combining so many things. Combining this and combining the tributes, and we cannot really join issues. I expect that after the discussants have spoken, we will take questions and answers and even take comments from some of us. But I plead, we may not have enough time, except we will shift it towards the end. We have some senior people who have come, elder statesmen who have come from Enugu, and they want to partake in the tributes. They want to say one or two things. Ezomenife came all the way from Enugu. He wants to say something about Chief Obia, knowledge Chief Obia. EEJ also came on that for that purpose, and we would like to hear from them. So I'll plead with you, let us jump some hurdles so that we can accommodate them. Otherwise, they will be traveling very late. For some of us, if we are here till 6 o'clock, I've eaten up today, I'm ready to stay here. There's nothing more. When I go from here, I go home and sleep, and then I can walk in the night. So please, if you agree with me, let's go to the second phase, so that we can move forward with your apologies. So on that note, I would like the MC to invite specifically the two personalities I've mentioned. We'll get back to the rest. Thank you very much.
Very well, my lord. Ezra Minute.
Honorable Chief Judge of Anambra State, who is the chairman of this session. I respect you and all the dignitaries here present. I say all protocols duly observed. We are here to honor one of us. As the chairman earlier said, so many people here. We are not lucky to know Chief Festus Mbanefo again. When I was in secondary school, each time we came on holiday, I used to see the signposts FM, Obianyo, and go along Modable Avenue by that road. Road. Yes, LLM. I used to see that sign first. But when I qualified as a lawyer, and after my national youth service, and I decided to set up my practice at Onitsha, I set up my first chambers at number 53 New Market Road. Lo and behold, behind my own office was a bigger office by FM Obianyo and Co. I learned a lot from him. One, that time, he was the external solicitor to the University of Nigeria when Professor Ndele was the Vice Chancellor. Helped me a lot. When I was lucky to be made an external solicitor to First Bank of Nigeria Limited, Union Bank of Nigeria Limited, then ACB, and Cooperative and Commerce Bank. Notwithstanding his busy schedule as a lawyer with good practice, he still found time to serve his God. He was so much interested in the music. And maybe I went along with him on some of those issues, but when it came to music, I was not good at singing at all. I didn't know she existed. People may not know that. But that notwithstanding, I saw a man who was embodiment of humility. He served his community. He served his God. There's no doubt about that. That was why the Almighty God gave him 100 years. It's not easy. And not only that, he lived 100 years. God blessed him with children and gave him a special daughter, Chinese. And I said, Chinese, the Almighty God who created you and gave you the will to look after your parents will give you people who will look after you. Amen. When I was introduced to some people. They said, from Idani, from Alo, I told them that this lady should be given a title. Why he come okay? Because he has done what his brother, a lawyer, could not do. I'll get